Hi everybody, welcome back to Help Solve the Case. We are here reviewing the pleading for a new trial, for suppression, for all kinds of things, for reconsideration in the Richard Allen trial, the Delphi murders. We've heard all kinds of things alleged by the defense: coercion, confinement, lack of evidence being shown, and we need to make sense of it. I appreciate that you're here. My name's Christine Burke, retired detective and sergeant, law enforcement expert, giving you my take on this. So let's continue. I think we're at the final end of this document, and then after this, we're going to proceed over to the state's response, and then the defense rebuts, and then we've got a hearing in about 4 months. Actually, it looks like 4 months today. And we'll see what happens. But we're looking at what the defense alleges the court and the state got wrong in the prosecution of Richard Allen in this case. So thanks for being here. Let's finish up and let's get into it. So one of the parts here is the defense is saying that the trial court, it's the judge, the court, committed reversible error in prohibiting the jury from hearing 2 phone calls Allen made on April 3rd, 2023. On April 2nd, Allen called his mother and discussed finding religion. In the early morning hours of April 3rd, Allen made 3 intertwined calls. Over objection, the jury heard the second call where Allen confessed to his wife, but the judge prohibited the jury from hearing the calls that bookended it, where Allen questioned his sanity and the veracity of his own statements, right? Now, if you're coming here from this very first video, I would suggest you watch the 4 previous ones. What we're talking about here is the defense seems to be alleging that the confinement, the pretrial confinement in solitary, there's the word, solitary confinement caused him to become psychotic, okay? And because of this psychosis, he then confessed, okay? He made these confessions, quote, confessions. And so what we're talking about here, or what I believe they're talking about here, is what they're saying here with these 3 calls, then that would mean, like, you hear people when they get quoted, they say, well, my quotes were taken out of context, okay? So it seems like what they could be saying here is that, in the first call, he was questioning his sanity and the veracity of his own statements on the front and back of that call, but yet all they took out of it, they took it out of context of this series of calls. Not sure. That's what it sounds like, okay? And then they say here, Trooper Harshman's testimony made the error worse. And he said, according to them, that when confessing, Allen was consistently, quote, calm, subdued, and solemn, end quote, in tone, showing no, quote, indication, end quote, of, quote, duress or stress, end quote. But the excluded April 3rd calls discredit his testimony. Allen was confused and forgetful in those. He believed he was losing his mind and that IDOC was poisoning him. He referred to being, quote, mentally tortured, end quote, comparing his environment to Guantanamo Bay. Independently, this error was harmful and warrants reversal. In closing, the prosecutor told the jury Allen started confessing on April 3rd because, quote, he'd given himself to Jesus, end quote, the day before. The excluded April 3rd calls tell a different story. Allen was losing his mind, showing lapses in memory and confusing dreams with reality. The prosecutor got to offer an inculpatory story for how the confession started, while Allen was prohibited from presenting an exculpatory through contemporaneous evidence. Okay, so inculpatory means showing guilt, lending itself to guilt, and exculpatory is not showing guilt, right? So what the defense is saying, well, how come they got to put this stuff in, but not this stuff, right? There's a balance there. We could get into statutory things and the whole thing, right? Okay, so why was it left out? So they say the trial court also erred by excluding the statements and behaviors that provided the foundation for Dr. Grasian's opinion that Allen's confessions were not credible. At trial, Dr. Grasian testified that Allen suffered from delirium, but the judge prohibited Dr. Grasian from discussing the statements that provided the foundation for his opinion, including Allen's statements that were patently false. This was reversible error. What they're saying here about reversible error means that the judge, they're alleging, this is the defense, alleging the judge made a boo-boo, that the judge made a bad decision that's reversible, like when they reverse it, okay? When it goes up to the higher court, they reverse it, and you'll see sometimes the case comes back for a new trial or a new division, a new decision, whatever. So that's what it means being reversed on appeal, okay? That decision was reversed. So they're saying this is reversible error. It needs to be fixed. They say first, Allen's false statements were not hearsay. He offered the statements to show his state of mind and prove that he was saying things unworthy of belief. Second, even if they were hearsay, the statements were admissible under Evidence Rule 703, which provides that experts may testify to, quote, to opinions based on inadmissible evidence, provided that it is of the type reasonably relied upon experts in the field, end quote. So here it appears that you have a mental health doctor who wants to use the defendant at that time, Allen's statements, okay? And you would think, I think what they're saying here is, well, of course, a mental health practitioner is going to make their decision and their treatment decisions on how the defendant presents themselves, one of which is talking to the doctor, right? I think that's what they're trying to say. And third, the statements were admissible because the state opened the door 3 times. Now, opening the door, talks about during the trial, there's rules prohibiting certain things coming in. There's precedent preventing certain things from coming in. And then the judge makes decisions about certain things coming in. But once somebody, leaves the door open, and the cat is out of the bag, so to speak, the cat runs out, okay? So they're saying the state opened the door 3 times to whatever happened here. So let's see. Trooper Harshman testified that Allen's confessions were consistent with the facts and included details, quote, only the killer would know, end quote. The state also paraded witnesses before the jury who opined, that's their opinion, that Allen's mind was intact when he confessed and that he was faking his symptoms. And Dr. Walla testified she saw no reason to screen Allen for delirium. Allen was entitled to counter all this with evidence that his statements were false, inconsistent with the murder scene, and consistent with delirium. Remember that confrontation clause we talked about in the earlier video? It's a constitutional provision, right? So that sounds like that's an accusation, right? So they want to counter that, okay? Independently, this error was harmful and warrants reversal. In closing, the prosecutor molded a story that despite Allen's undisputed psychosis, his confessions were truthful. The judge affected the jury's decision when she prohibited Allen from showing that he made repeated untruthful confessions. Together, the above 3 errors violated the Constitution. The Constitution prohibits a court from, quote, stripping a defendant of the power to describe to the jury the circumstances that prompted his confession. And they're using Crane here. I don't see the end quote. Sorry, guys. They say that is precisely what occurred. Allen repeatedly presented evidence that placed his confessions into context. We talked about that earlier, and impeached their credibility, but the judge arbitrarily excluded the evidence and disproportionately ruled in the state's favor. F. The trial court committed reversible error in denying Allen's motion to correct errors. Allen timely filed a motion to correct errors, arguing the state elicited false testimony and allowed it to go uncorrected. The trial court denied the motion. The 14th Amendment is violated when the prosecution knowingly solicits false testimony or knowingly allows it to go uncorrected. And they're citing 2 cases here, Glossop and Napui. Okay. According to Dr. Walla, says the defense, Allen confessed that he was attempting to rape the girls, but abandoned his efforts and fled with them across the creek when he saw a van. At trial, the state elicited testimony from Brad Weber, who told the jury he left work at the Subaru factory in Lafayette, Indiana, around 2:02 p.m. on February 13, 2017, and drove his white cargo van directly home. The prosecutor told the jury that the timeline for Weber's testimony, Allen's confession, and the step data on LG's phone matched perfectly and proved Allen guilty. It says, and this is his testimony, probably. If you take a look at the health app data, there's a pause in the movement for 7 minutes. He has 7 minutes with them. But before he can finish his deed or his deeds, he sees a van. Brad Weber's coming home from work down his private drive to his home, and he scares Richard Allen. Then Richard Allen forces the girls across the creek to a spot in the woods, a secluded spot, and he kills them. He cuts their neck. The defense is saying Weber's testimony was false and the state knew it. Specifically, security camera footage from Weber's neighbor showed him arriving home at around 2:44. An FBI report showed Weber's cell phone arriving home around 2:50 p.m. Okay? So, this 2:02 p.m. apparently driving directly home, I don't know how long that takes, okay? But they're alleging some time discrepancy here. The error was constitutional and requires reversal. It requires reversal if it would have, quote, could have contributed to the verdict, end quote. They say here, the false, excuse me, the false evidence, if corrected, would shown, typo, that Weber's arrival home was inconsistent with the state's murder timeline. He arrived home 25 minutes after the pause in movement on LG's phone and nearly 15 minutes after LG's phone was on the other side of the creek and hundreds of yards away from Weber's home. So it sounds like what they're saying is supposedly the 7 minutes and then Allen saw the van and then moved the girls. That's what it sounds like they're saying the state said. But here the defense is saying he didn't get home for Allen to see him until 25 minutes after the pause. So the timing doesn't seem to make sense, okay? So they're saying, thus, Allen's statements to Walla are inconsistent with the truth and suggest he was delirious. The error requires reversal. They also say that the trial court committed reversible error when it excluded Allen's evidence explaining this murder as a ritual killing. The trial court prohibited Allen from explaining the murder scene as a ritual killing. This was reversible error. Evidence which tends to show that someone else committed the crime logically makes it less probable that the defendant committed the crime and thus meets the definition of relevance in Rule 401. Here, Allen tendered Don Perlmutter, a recognized expert in ritualistic killings and atypical homicides, to explain the elements of ritual killings. Rituals killings commonly occur outdoors in wooded areas and near bodies of water. They occur on holidays significant to the group and commonly often involve the use of ceremonial knives. There will be symbolism at the scene, and with Norse pagan rituals, the symbolism will likely involve runes, arranging natural objects in a specific way, and perhaps combining the runes with blood, i.e., quote, blooding the runes, end quote. Quote, you don't get bullet wounds, end quote, with ritual murders. Rather, there is usually throat slitting, blood loss, and perhaps torture. You would expect the sacrifice to be displayed or arranged at the scene in a manner that is significant to the group. And finally, you would expect to see an atypical or symbolic pattern at a ritual killing. According to Perlmutter, the murder scene included all these elements. The murder occurs outdoors in a clearing near a large creek. The murders coincided with the Nordic holiday Valsblot, which honors Odin's son, Vali. The girls' throats were cut with a knife and they bled extensively. Talking about, not to be gross here, but a sacrifice. Okay? Perlmutter found the sticks to be obvious symbolism and difficult to explain in any other way. In her opinion, the stick arrangement on AW mirrored the Norse rune, quote, Gebo, end quote, and the stick formation on LG looked like a Nordic, quote, bind rune, end quote. Perlmutter also explained that the bodies were arranged in a manner consistent with a pagan ritual. An upside-down hanging body is an important element of Norse paganism because Odin hung from a tree for 9 days before discovering runes. And I know nothing about what this is, okay? And Odin's leg is often displayed with one leg bent behind the other. Here, the blood patterns on the girls' faces suggested a person lifted their bodies and articulated their torsos and necks above their chins. AW's leg was bent behind the other, mirroring the classic image of Odin, and the blood pattern on the tree appeared to look like a Norse pagan Fihu rune. Perlmutter had the knowledge, skill, and experience to offer this testimony. Expert testimony should be admitted if 1. The expert is qualified, quote, by knowledge, skill, experience, training, or education, end quote, and 2. The testimony, quote, will help the trier of fact to understand the evidence or determine a fact in issue, end quote. So here, Perlmutter is an expert in ritualistic killings and a recognized federal subject matter expert on atypical homicide and ritualistic crime investigation. She is the author of Ritualistic Crime Scene Investigation, a field guide for law enforcement officers investigating ritually motivated crimes. She teaches about ideological and ritualistic killings, and she is familiar with the practice of Norse paganism or Odinism. She was qualified to offer her testimony. Perlmutter's testimony was not conjecture. There was, quote, always a discussion, end quote, among law enforcement that this may be a ritual murder and that the sticks were Nordic runes. The BAU, that's the FBI's BAU Behavioral Analysis Unit, declined to exclude pagan ritual as a plausible explanation for the murder scene. A consulting professor found it, quote, quite plausible, end quote. The stick markings, quote, constitute an instruction inspired by Norse runes or modern recreations thereof, ... end quote. And an undercover law enforcement officer familiar with runes also found pagan symbolism at the scene. Perlmutter's testimony would be helpful to the jury. Although motive is not an element of murder, juries want an explanation for the crime. And when the motive is unclear or inconsistent with the defendant's guilt, juries are more likely to acquit. Similarly, when a murder scene is so complex or unusual, it is important the jury receive an explanation. Here, the murder scene was complex and unusual, and the jury would naturally want an explanation. The sticks immediately stand out to any rational person as unusual and warranting an explanation. Perlmutter's testimony provides an answer, explains the scene, and offers a motive. Her testimony would be helpful to a jury. Excluding Perlmutter violated the Constitution. A defendant is entitled to answer the prosecution's case with his, quote, version of the facts, end quote, so the jury, quote, may decide where the truth lies, end quote. And I talk pretty frequently about the Netflix effect that both sides are putting their story on, and they want the viewer to reach their logical conclusion, okay? They continue, and a judge cannot infringe upon this right through the arbitrary, disproportionate, or mechanistic application of the rules of evidence. Accordingly, if the state offers an inculpatory explanation, meaning a damning explanation for the evidence, trial courts cannot use the rules of evidence to prohibit the defendant from offering an exculpatory explanation. So if they're going to say how you did it or why you did it, then you get to put something on saying, no, that's not the truth. Here's what happened or whatever. By excluding Perlmutter's testimony, the trial court allowed the state to offer an inculpatory explanation for the murder scene while denying Allen his constitutional right to offer an exculpatory explanation, right? That confrontation clause. This arbitrarily and disproportionately denied Allen his constitutional right to prevent a defense. But the error was not harmless. The state told the jury repeatedly this case was about a, quote, brutal, end quote, murder, and it explained the evidence in a manner that incriminated Allen. The jury received a one-sided explanation for the crime without Allen being able to counter it. This error affected Allen's substantial rights and altered the jury's decision. The trial court denied Allen his right to show the state's investigation was incomplete, overlooked plausible leads, and mishandled evidence relating to third-party guilt. The trial court prohibited Allen from presenting any evidence regarding the manner, quality, and thoroughness of the investigation into this murder as a ritual killing. A defendant is entitled to have his case proved beyond a reasonable doubt. And the accused can create doubt by showing the investigation was incomplete, overlooked plausible leads, or that law enforcement mishandled evidence relating to a third party's guilt. They're getting that from Winship. Okay. Here, Allen presented evidence that the state's typos performed an incomplete investigation, mishandled and destroyed evidence, and overlooked plausible third-party leads connected to pagan rituals. After examining the scene, several officers believed it was too complex for just one person to be involved. And the Carroll County Sheriff immediately thought the sticks related to, quote, pagan rituals, end quote. The day the girls went missing, law enforcement learned that A.W. was having a secret relationship with N.L.H., the son of Brad Holder. That week, law enforcement interviewed Holder and his friend Patrick Westfall. Holder reported being involved in a pagan, quote, tribe, end quote, and spending, quote, every weekend, end quote, in Delphi, engaging in pagan rituals with Westfall and 5 or 6 others, including women. These rituals involved animal sacrifice and human bloodletting. I don't know what that human bloodletting is. Sounds awful. I don't know. Holder told police he owned a .40 caliber gun, like the bullet found, right? But officers did not examine or collect the weapon, nor did they search his phone. Holder told police he was at work at Liberty Landfill when the girls went missing. Law enforcement recorded over his interview, permanently deleting it. In his interview, Westfall told law enforcement he knew the woods where the girls were murdered, quote, very well, end quote. He reported knowing the girls but denied ever meeting them. He also reported being a religious leader for local pagans, and he wore a necklace to the interview representing his efforts to pledge the, quote, Vinlanders, end quote, a pagan, quote, social club, end quote. Law enforcement neglected to record Westfall's interview, and when asked for an alibi, Westfall claimed he was home with his minor son. In the 5.5 years between Westfall's interview and Allen's arrest, law enforcement took no further action. After Holder's interview, tipsters repeatedly called and reported him as a person of interest, claiming he posted pictures of, quote, half-dead women, end quote, with, quote, symbols out of tree branches, end quote. On April 13, 2017, officers visited the landfill to investigate and spoke with an employee, Susan Case, who provided a printout showing Holder swiped out of work at 2:45 p.m., which was 30 minutes after the Bridge Guy video. Case invited the officers to review the video to confirm the printout's accuracy, but they declined. Nor did they interview other employees. Unified Command marked Holder as a, quote, cleared, end quote, suspect. In April 12, 2017, shortly before taking medical leave, Trooper Winters received a call from a tipster, Ryan Boucher, who shared pictures from Holder's social media. Winters found a concerning similarity between the murders and pictures posted on Holder's social media. Those pictures depicted, quote, young girls believed to be deceased with sticks placed over their bodies, end quote. Winters also noted similarity between the stick formation on AW and a bind rune Holder tattooed and drew on his hand. Holder, I guess that's his statement, quote, that's a bind rune on my hand. Basically, I took a Gebo rune and an Isa rune and I made a bind rune, end quote. Whatever those are, I don't know what those are. Holder's social media also featured him holding guns and, quote, homemade knives, end quote. Winters immediately recommended to his superiors that law enforcement investigate Holder further, which they declined to do, claiming his alibi was cleared by the FBI. Holder displayed a painting he made of Odin upside down with his right leg tucked behind his left, just like AW's legs. Holder's painting also featured a red Fihu rune. Winters was not satisfied and urged the ISP to conduct its own investigation. No further action was taken. In September 2022, the state charged Allen. At Allen's insistence, law enforcement re-examined Holder, and Holder's story about AW began to change. Back in 2017, he told law enforcement he, quote, never actually met AW, end quote. But in August 2023, he told law enforcement he met AW once. And during a deposition in 2024, he said he met AW, quote, 2 times, twice, end quote. At least one of those encounters occurred shortly before AW's murder at Westfall's home. On April 4th, 2024, Allen's counsel deposed Case, the Liberty Landfill HR officer, and found that Holder did not have exclusive control of his employee badge on the day the girls went missing, i.e., could somebody have swiped out for him? You know, have you ever worked at a job where you got to punch a time card and say, hey, can you punch me out or something like that, right? That's what they're talking about. Allen also uncovered evidence that impeached the course of the investigation even further. In 2018, Holder told his fight he, quote, had a fight, end quote, with Westfall, quote, because Westfall wanted to up from animal slaughter to a different type of sacrifice. Holder then told her that, quote, Westfall killed AW, end quote, with others, end quote, and that she needed to keep her mouth shut about it. The evidence shows a shoddy, incomplete, and mishandled investigation into this murder as a ritual killing and raises a reasonable doubt that Holder and Westfall were responsible for the murders. Allen was entitled to present this evidence to the jury, and the judge committed reversible error by excluding it. The error violated the Constitution and affected the jury's decision. The Constitution entitles a defendant to, quote, attack not only the probative value of crucial physical evidence and the circumstances in which it was found, but the thoroughness and even the good faith of the investigation as well, end quote. Okay, that's from Kyles versus Whitley. And they got some other cases here too. They say, here, the omitted evidence created reasonable doubt and raised questions of the utmost importance about the manner, quality, and thoroughness of the investigation that led to Allen's arrest 5.5 years after the murders. Had the jury heard it, a different result was likely. So, they say, in conclusion, quote, the very premise of our adversary's system of justice is that partisan advocacy on both sides of a case will best promote the ultimate objective that the guilty be convicted and the innocent go free, end quote. That's from Herring v. New York. It's they, because the trial court prohibited the jury from hearing Allen's side of the story, showing how law enforcement went down the wrong path, justice could not be done. Appellant Richard Allen requests this court reverse his convictions, okay? So, 24,000 words. All right. Whew, what do you think? So now the state has rebutted this. They've responded to it. And then we have more from the defense prior to the hearing, the upcoming hearing. So I will work on those. But I'll get to that. Thanks for being here. Love the comments. Let me know also in the community whatever other cases you'd like to see. And what you'd like me to work on. And I hope you found this valuable. If you have, like, subscribe, share. I really appreciate it because it helps me move this case forward. Thanks for being here. I'll see you on the next one.